Hello, I'm Mavluda Sattorova, and today I would like to briefly outline my recent research into the impact of international investment law on host states, particularly developing countries. Traditionally, international investment law was conceptualized as a set of norms designed to ensure good governance for foreign investors in exchange for their capital and know-how. Recently, however, as the number of investment treaties and investment arbitration cases has surged, the scope of foreign investment protection and the extent of state exposure to monetary liability dramatically expanded. Investment treaty instruments have moved far beyond their original task of safeguarding foreign investors against outright takings of property and denial of justice. Investment treaties now allow investors to claim redress even for governmental actions displaying a relatively lower degree of inappropriateness. Lack of transparency, stability, predictability, as well as lack of effective remedies and enforcement mechanisms at a national level can now lead to host states' liability and damages. As the development function of investment treaties is being increasingly contested, and the magnitude of its financial consequences for respondent states remains highly troubling, the question is, are investment treaties solely for the benefit of the investors? Should investment treaty law also fulfill some useful societal function? So, as if in response to the growing criticisms and concerns about the investment treaty regime, new narratives have emerged claiming that investment treaties and investor-state arbitration are useful because they can improve governance not just for foreign investors, but also for host states and for host communities. In other words, even if investment treaties are expensive for host states and unsuccessful in delivering on their original development promise, they could still be useful in promoting good governance in developing countries. Investment treaty law can arguably do so through good governance standards that are enshrined in substantive treaty provisions, such as the Fair and Equitable Treatment Standard. Although designed to benefit foreign investors, these norms may arguably eventually spill over into domestic law and set new standards also for the domestic legal system, pushing the host governments to undertake reforms and to embrace good governance standards in their daily practices more widely. The recent recurrence of such narratives in investment treaty practice, arbitral awards and academic literature raises questions as to their juridical, conceptual and empirical underpinnings, as well as practical implications for host states. I investigate some of these issues in my forthcoming book, titled The Impact of Investment Treaty Law on Host States. The principal question of the book is whether investment treaty law can exert a positive influence on host states by fostering host state compliance with good governance standards at the national level. In conducting this study, I used doctrinal, comparative, empirical and normative analysis. Among other things, in examining the interplay between investment treaty disciplines and governmental conduct, the book draws on emerging empirical data. The good governance narratives of international investment law are grounded in a set of assumptions about how host states should respond to investment treaty norms. It is presumed that the imposition of monetary liability on host states for a breach of good governance standards will not only deter host states from mistreating foreign investors, but also encourage them to proactively reform legal and bureaucratic practices at home. For such deterrent and transformative effects to exist, however, government officials and host states need to be aware of the existence and meaning of investment treaty prescriptions. Moreover, national legal and regulatory frameworks should be in place to discourage individual government officials from acting in breach of those good governance prescriptions. But the question is, to what extent are government officials in developing countries actually aware of and influenced by investment treaty disciplines in making their decisions vis-à-vis foreign investors? Does the imposition of monetary sanctions on the host state prompt host states to address the governance failures lying at the roots of investor-state disputes? How do host states respond or react to their experiences of defending themselves in investor-state disputes? The book engages with these questions by situating the good governance narratives within the emerging empirical data, including the findings obtained through interviews with government officials and the analysis of national legislation in 5 developing states. Notwithstanding their relatively modest scale, the case studies offer potentially very illuminating insights. For instance, it transpires that even after the host states encountered investment arbitration in a respondent capacity, many government officials tended to remain unaware of the true reach of investment treaty law and its practical implications. Even where government officials learned about investment treaty law from their involvement in investor-state arbitration, such learning has not always been translated into concrete legal reforms. The interviews also reveal that, despite having gained some awareness and knowledge of investment treaty law, some host government officials often continued to neglect the possible repercussions of their actions under investment treaty rules. In some cases, rather than encouraging states to embark on governance reforms, the dissatisfaction with investment arbitration have propelled host governments to seek retroactive changes in national laws on investment protection. And in some cases, we know that the governments have announced their decision to withdraw from the investment treaty regime altogether. My research also examines the emerging trend towards the creation of national investment promotion and dispute prevention agencies, such as those witnessed in Brazil, Colombia, Kazakhstan, Peru and Ukraine. Could the newly established investment ombudsman and similar dispute prevention bodies be a manifestation of a reformist impulse triggered by the host state learning from their encounter with investment treaty law, as predicted by the proponents of the good governance narratives? Both the analysis of national legislation, comparative studies and interviews suggest not. These policy developments appear to owe their origins to the investment facilitation agenda actively pursued by international institutions and Western donor organizations. The question is, does the involvement of these international organizations in shaping national responses carry an enabling effect on governance in host states? Or does it effectively prevent host states from formulating and implementing their own choices with respect to investment protection, promotion and dispute settlement? The content of the rest of the book has been inspired by the findings from the case studies and in particular interviews. The empirical evidence suggests that, due to its emphasis on the idea of foreign investors deserving special protection, the investment treaty regime contributes to a fragmentation of the national judicial and regulatory landscape and the emergence of special decision-making bodies specifically tasked with shielding foreign investors from dealing with national law and institutions. Rather than encouraging a comprehensive reform of national governance practices, host governments appear to favour solutions offering good governance only for foreign investors, not good governance for all. Contrary to the assumptions that foreign investors can foster good governance by lobbying host states or otherwise pushing for national reforms, the emerging evidence from investment arbitration practice and from our interviews revealed genuine grounds for concern over the negative impact of foreign investment on governance in host states. Through their contribution to normalizing corruption, bribery and regulatory capture, foreign investors may at times entrench poor governance in host states. And failure to address lack of investor accountability in international investment agreements and arbitration practice is starkly at odds with the investment treaty regime's proclaimed commitment to the ideals of rule of law and good governance. Among its many conclusions, the book suggests that further studies are warranted to explore how those who ultimately bear the costs and benefits of investment treaty rules, that is, developing states and host communities, could be genuinely, not tokenistically, included in the process of redefining investment treaty objectives and shaping the content of investment treaty norms. I argue that the current fashion for the creation of legal enclaves for foreign investors, not only at the international but also national levels, merely entrenches the prevailing perceptions of international law as a forum for the select privileged actors. Capacity building is another tremendously important issue. Governance reforms in developing states do require some capacity building support, but the latter needs to be designed so as to empower national actors rather than merely increasing the sphere of influence of international agencies. Thank you for listening.